Welcome to the Law Offices of Sabrina Lee's YouTube channel. Sabrina is recognized as a State Bar of California Certified Legal Specialist in Immigration and Nationality Law, a prestigious distinction held by less than 1% of attorneys. Today, we have an incredible successful story to share that embodies our motto, Your American Dream, Our Commitment. If you found this video valuable, please like, subscribe, and share with your friends and family. Our client, a research scholar, entered the United States on a J-1 visa with his spouse, who held a J-2 dependent visa, to participate in a U.S.-funded program. During their time in the U.S., they welcomed a child who is a U.S. citizen. After completing the program, our client received a job offer and hoped to remain in the U.S. However, the J-1 visa's 2-year home residency requirement mandated that he return to his home country before becoming eligible to apply for another U.S. visa or permanent residence. Because the client's program was funded by the U.S. government, he was not eligible for a no-objection waiver. Recognizing the obstacles posed by this requirement, he came to our office to explore alternative waiver options. Through in-depth discussions, we discovered that our client's U.S. citizen child suffered from recurring health issues that required ongoing, specialized medical care only accessible in the U.S. Relocating to the client's home country posed significant risks for the child, given limited healthcare resources and prevalent antibiotic misuse. We identified the exceptional hardship waiver as the most suitable option under I-212. To meet the high standard of exceptional hardship, we meticulously compiled documentation demonstrating the unique challenges the family would face. This included medical reports on the child's condition and the critical need for consistent follow-up care in the U.S. We also demonstrated that the family's financial stability here was essential to covering these medical needs, which would be jeopardized by forced relocation. Additionally, we provided evidence of specific health and healthcare challenges in the home country, including shortages in qualified care providers and risks associated with antibiotic overuse. After 2 years of waiting, USCIS finally approved the exceptional hardship waiver, allowing our client and his family to remain in the United States. For many J-1 exchange visitors, the 2-year home country residency requirement under Section 212E of the Immigration and Nationality Act can be a substantial hurdle. This requirement mandates that certain J-1 visa holders must spend 2 years in their home country before they can apply for specific U.S. visas or status adjustments. However, if fulfilling this requirement isn't feasible, there are waiver options available. Importantly, the waiver application must be approved by the Department of Homeland Security before any change of status or visa issuance in certain categories. The 5 possible bases for a J-1 waiver are: no objection statement, request by an interested U.S. federal government agency, persecution, exceptional hardship to a U.S. citizen, or lawful permanent resident, spouse or child of an exchange visitor, and request by a designated state public health department or its equivalent, Conrad State 30 program. If you or someone you know is facing a challenging immigration situation involving the J-1 2-year residency requirement, we're here to help. Contact us today at 213-375-8096 or email us at info@sabrinalee.law.